here today to moderate the panel on dismantling the Doctrine of Discovery. We have a number of very distinguished panelists here to share their thoughts and ideas with us today. And we also have a message from the Assembly of First Nations National Chief Harry Bellegarde. So I will begin with that message. My thanks and welcome to all of you today who are participating in this important panel discussion, Dismantling the Doctrine of Discovery, the Road to Reconciliation. Noted legal scholars in Canada and beyond have called into question Eurocentric and racist legal doctrines still employed to deny recognition of Indigenous peoples' pre-existing sovereignty and legal orders in favor of colonial assertions of sovereignty. The Doctrine of Discovery is one of these. In R.V. Guerin, the Supreme Court of Canada referenced this doctrine as justifying European claims to ultimate title on the land in favor of the nation which had discovered and claimed it, and as explaining the purportedly limited nature of First Nations interests under the common law of Canada in our own lands relative to that of the Crown. Anishinaabe legal scholar John Burroughs has summarized the problem well. He says, "It is factually apparent that at Canada's formation, there was no first discovery on the part of the Crown that would justify displacing Indigenous law. Indigenous peoples had already discovered most land within their territories and exerted jurisdiction over it prior to the arrival of Europeans. If any legal consequences flow from discovery, these should vest in favor of Indigenous peoples, not the Crown, if this doctrine was applied without discrimination." Some of the leading experts in the world on this topic are here with me today, such as my friend and colleague, Grand Chief Ed John. Your discussion and work are vital to the ongoing struggle to achieve reconciliation by bringing Canadian law into line with the equal rights of peoples under international human rights law. This will require dismantling the remaining underpinnings of colonial thinking and Canadian common law that serve to treat Indigenous peoples as less than equal, respecting our relationship to land and our rights to land in our traditional territories. Thank you for your attendance as part of our collective march to reconciliation and social justice. So that was the message from National Chief Harry Bellegarde. So as was mentioned, we have wonderful panelists with us today. The first is Grand Chief Edward John, who is a hereditary chief of his nation located at the banks of Nakalbun. Grand Chief Ed John has dedicated his life to the pursuit of social and economic rights for Canada's Indigenous peoples. He holds a BA from the University of Victoria, a Bachelor of Laws from the University of British Columbia, and an honorary Doctorate of Law from the University of Northern British Columbia and the University of Victoria. He is an elected member of the First Nations Summit Political Executive, which is mandated to carry out tasks on issues related to Crown First Nations negotiations in BC. He is an expert member and former chair of the UN Permanent Forum on Indigenous Issues. Chief John was directly involved in the development of the United Nations Declaration on the Rights of Indigenous Peoples. He will be our first speaker today. Our second speaker will be Bishop Mark MacDonald. The Right Reverend Mark MacDonald became the Anglican Church of Canada's first national Indigenous Anglican bishop in 2007 after serving as bishop of the U.S. Episcopal Diocese of Alaska for 10 years. At present, he is also serving as the North American president of the World Council of Churches. He has held long and varied ministry positions all across Canada and the United States. He is the author and co-author of several publications touching on topics such as sacramental connections between faith and the environment, and joining multiculturalism and evangelism. He is an advocate to all Canadians for a return to the gospel where there is understanding, reconciliation, and love between Indigenous and non-Indigenous peoples. Our third speaker is Jennifer Preston, who is at the table here. Jennifer is the program coordinator for Indigenous Rights for Canadian Friends Service Committee, the Quakers. She was actively involved in the intensive lobbying efforts to ensure the successful adoption of the UN Declaration on the Rights of Indigenous Peoples, both in Geneva and in New York. Her work is now focusing on implementation of the Declaration. She is a co-author and contributor to Realizing the UN Declaration on the Rights of Indigenous Peoples, Triumph, Hope, and Action. For the past 7 years, she has written the Annual Review of Canada for the Indigenous World, for the International Working Group on Indigenous Affairs. Our next speaker will be Stuart Waukee, who is seated to my left and your right. Mr. Stuart Waukee currently serves as General Counsel for the Assembly First Nations. He oversees all legal matters and compliance issues for the AFN, and in addition to legal representation in the courts and tribunals, Mr. Waukee provides advice on matters relating to Aboriginal and treaty rights, consultation and accommodation, corporate governance, and the environment. He acted as counsel for the Assembly First Nations in a number of matters before the courts relating to the implementation of the Indian Residential School Settlement Agreement. Prior to this role, Mr. Waukee's work focused on the environment, extending to both domestic and international dialogues on a variety of subjects. Mr. Waukee also served as legal counsel for the Southern Chiefs Organization and Garden Hill First Nation. So as you can see, we have some very learned people participating in the panel today. They will each have around 10 to 15 minutes to provide their presentation to you, after which we will hold a discussion and Q&A. You'll notice that we are filming this event, however, we will not film the discussion Q&A as there are a few lawyers on the panel and we realize we haven't provided waivers. So, keeping that in mind, we will be careful to avoid filming anyone who does not wish to be filmed. So, just in terms of a very brief introduction from my perspective, it was quite interesting that earlier this week I was in Edmonton for a conference called the Global Commons Conference. And at this conference, we heard a presentation from an organization called the Native Youth Sexual Health Network. This organization has done incredible work internationally for Indigenous youth, as well as on the issue of sexual health, reproductive justice, and environmental violence. And there was this wonderful painting that one of the young ladies who works for this organization had done. It's sort of a figure of a girl with her hands over, her body, with sort of some nuclear signs and representations of oil wells and representations of indigenous land in the image. And she called it, "Our Bodies Are Not Terra Nullius." And I thought that was so profound for me coming here and thinking about this particular panel, because we're not just talking about lands and territories when we think about the Doctrine of Discovery or the concept of terra nullius. We are talking about almost every aspect of what it means to be an Indigenous person, to have a spirit and a soul, to have a body, to be connected to family, to be connected to our nations and our lands and territories. And what was so interesting about her presentation was that she said, when we started doing work on reproductive justice and thinking about sexual health and wellness of Indigenous youth in particular, we could not separate it from lands and territories. We had to talk about lands and territories, and we had to confront the Doctrine of Discovery in order to do that. And so to me, it's just a very wonderful example of how profound and far-reaching this doctrine has been and continues to be. And so I'm very much looking forward to the presentations of all the panelists, and without further delay, I'm going to hand the mic over to Banshee and John.
Thank you, Danica. To my fellow panelists, good morning to all of you as well. My name is Kai Jo. It's a hereditary chieftainship name for my people's territory. And under the traditional authority of our governments, these names and authorities are handed down through the generations. Much like many other tribes, indigenous peoples across the country, I went to the Jack Indian Residential School for many years. It's located in the central part of British Columbia. It's run by the Catholic Church, operated by the Oblates, and set up by the Government of Canada. And many of our peoples in my community and all of the neighboring First Nations communities Ended up going to school there. At least 3 generations. It opened in 1922 and it closed in 1976. My community is pretty much in the middle of my people's territory. Other people think it's in the middle of nowhere, but it's our homeland, and the nearest town is like 40 miles away. And Canada, just the way we like it, we don't really like being crowded by too many folks as we've seen in other parts of the country. Yesterday, I participated in that walk. I see some of the media wants to call it a march, but it's really a walk. And I did it to remember my late mother and dad who went to residential school as well. And my dad told me that, asked him why he sent us to a residential school. He said, not the public school nearby. We were living in Fort St. James at the time, and he said, well, you know, son, you were not allowed to go to school there, the public school. Indians weren't allowed. And that was, and I checked the law of the land then, and of course he was right. I didn't doubt it, but I wanted to make sure how it happened. And the provinces have a responsibility, as do the federal government. He did not go to school, but he was supposed to in the RCMP, and game warden came to our village and told my grandparents that if they didn't release him, they would end up in jail. So they let him go. And that's a bit of the story, just my background. So yesterday I remembered them and many others in that walk to City Hall here. And along the way, I listened to the church bells ringing across from the Supreme Court of Canada. I thought it was significant that these two institutions, side by side, that we would hear the church bells ringing the message of reconciliation, I thought. And across on the other side was the Supreme Court of Canada, whose decision ultimately broke the back of the resistance by churches and the government of Canada in a case called Blackwater. And that really opened up all of the events that we have been involved in over the last many years. As I walked by there, I thought about what Chief Justice Doctrine had to say, that this was an attempt at cultural genocide in residential schools. And I think it was really more than an attempt. I think for many it was actually cultural genocide. It wasn't just an attempt, but for sure it was a very serious attempt at many successful, on fronts it was successful. And we'll explain some of that today. But I remember the story in the media about the federal government of this city hall here, the controversy over a proposal by the federal government to set up a monument to the victims of communism. And I'm walking by and thinking, well, maybe we should have a monument to the victims of democracy. Being Indian residential school survivors of the many victims that have gone forward. Anyways, I doubt it they really would think about it. They do have a little window that they painted over at Parliament Hill, and probably sufficient for their purposes. But when I went to that place to see it, I was actually turned away by the security at the front. Couldn't really explain why, but that's what happened. But neither here or there. In the Doctrine of Discovery, what the hell is the Doctrine of Discovery? Well, there's moral authority underneath that really began with the whole notion of Christianity and the role of Christianity, in particular the Christian churches, the Catholic churches, and you think back to all of those crazy movies about the Crusades and all of that. Part of that crusade came to the Americas and to other continents in many respects. And the moral authority came in the form of papal bulls, the orders from the popes in Rome, that provided the underpinning what became international law, called the Doctrine of Discovery, that whoever founded and settled and colonized the land, whoever found it could claim that land on behalf of the sovereign, whether it was Queen Isabella of Spain or the kings in France or England, the queens in England. That was the law as between themselves. There wasn't certainly a law for indigenous peoples or others in other parts of the world. And that doctrine of discovery was applied in the United States. And I want to go to the source of it on this continent, and it's a trilogy of cases by Chief Justice Marshall in the U.S. Supreme Court. And in Johnson McIntosh in 1823, the origins of the concept of Indian title and the conceptual framework for the doctrine of discovery were considered. And in several quotations from that, quotation one, on the discovery of this immense continent, the great nations of Europe were eager to appropriate to themselves so much of it as they could respectively acquire, end of quote. The rulers of the old world found no difficulty in convincing themselves that they made ample compensation to the inhabitants of the new by bestowing on them civilization and Christianity, end of quote. Goes on, to avoid conflicting settlements and consequent war, it was necessary to establish a principle, which was that discovery gave title to the governments by whose subjects or by whose authority it was made against all other European governments, which title might be consummated by possession, end of quote. You quote, the right of discovery, 1496 Commission to Cabot by the Queen of England, is confined to countries then unknown to all Christian people, thus asserting the right to take possession notwithstanding the occupancy of the natives who were heathens. And it's the Chief Justice talking. Our Chief Justice is actually talking a different language here, but this is 1800s. The rights of the original inhabitants were necessarily, to a considerable extent, impaired. The rights to complete sovereignty as independent nations were necessarily diminished, and their power to dispose of the soil at their own will was denied by the original principle that discovery gave an exclusive title to those who made it, end of quote. The USA maintained that discovery gave an exclusive right to extinguish Indian title of occupancy, either by purchase or by conquest, and also gave a right to such a degree of sovereignty of the people would allow them to exercise. And so that case by Chief Justice Marshall really established for the first time in a legal context what the doctrine of discovery was and what its implications were. And so in 1886, in the case called St. Catherine's Milling, in this country, a fight between the government of Ontario and the government of Canada as to who had the right to issue timber licenses in the lands that were settled under Treaty Number 3. And in that case, the Judicial Committee of the Privy Council, then the final Court of Appeal in this country, decided that Justice Marshall's doctrine and the notion of Indian title would be incorporated into Canadian law. And so that case was the first time in this country where that doctrine was actually came into play. And subsequent to that, in the reference to Guerin versus the Queen, Delbert Guerin being the late Delbert Guerin being the former chief in Musqueam, and the case against the government of Canada, the court and subsequent cases reiterated the law that originated with the martial courts. And so, even though it has never been argued by plaintiffs or by First Nations directly in the courts, our court continues to simply, by the rule of precedent, apply those cases that have been decided quite a long time ago. There's yet to be a case where these issues are directly challenged in the courts in this land. So the manifestations are many. So in British Columbia, there were never any agreements or treaties. Simply in February 14th, 1859, the former colonial governor James Douglas issued a proclamation regarding British Columbia. Originally, there was another proclamation that set out the province of British Columbia and set out the boundaries. And subsequent to that, issued this proclamation that all the lands in British Columbia and all mines and minerals therein belong to the Crown and fee. Simply, just like that. And so, it is an exercise of the underlying premise of the Doctrine of Discovery that they have the right to take the lands as they see fit. And they did. And so, these are issues that are still very much alive. They're not something, the Doctrine of Discovery is not something that's ancient and back there somewhere. It is very much alive today when it relates to land and resources. Indigenous governments were abolished, and the Crown fought very hard to do that. The spiritual practices, the potlatch laws of our peoples and the Sundance practices of the peoples of the prairies were outlawed as well. It was illegal from 1927 in British Columbia and other parts of the country for Indian people to gather to talk about Indian land rights. And so we've seen over the years how we've made efforts to try to dismantle the Doctrine of Discovery, case by case by case in the courts, issue by issue by issue in the blockades, or in this case involving residential schools. We are, I think, making significant strides in this country now to address it, but the underlying premise is still very much there. How do we dismantle it? How do we deal with it? And so the UN Declaration on the Rights of Indigenous Peoples that was passed by the United Nations General Assembly, the September 2014 United Nations World Conference on Indigenous Peoples, and the outcome document are all parts and parcel of not just the dismantling of doctrines like that in this country, but elsewhere involving other Indigenous peoples. 370 million Indigenous peoples globally, and collectively working together. I think there have been significant strides internationally. The application of these principles, though, continue to be elusive in this country, and so that work carries on, and we carry on. Our kids and our grandkids will pick up this fight. It won't end, but it was very good to see the turnout yesterday. 7,000 people who together marched and walked to make a point that now's the time to make the transitions and the changes that are fundamentally important to this country's future and for the survival and the dignity and the well-being of our peoples. So thank you, Danica, I much appreciate it.
Thank you, Grand Chief John. I'm now going to pass the floor to our next speaker.
I'm very pleased to be a part of this conversation and to talk about, more specifically from the Church's point of view. Throughout this period of truth and reconciliation, the Church has often described itself as being complicit with colonization. To me, that's kind of like someone who planned the bank robbery, drove the car there, and got the drove away with the car is complicit in a bank robbery. The church, using the title doctrine, helps to underline the very unique, animating role that the church played in the development of this idea. We see it as a spiritual problem, which modern people will normally just think of as being religious, but by spiritual, we would say that it has moral, intellectual, psychological, communal impact. And I would say that we see this on three primary levels. One is the religious aspect of it, the other is the legal aspect of it. And the third level, which I think is critical, is the systemic aspect of it, that it is an idea that not only hypnotizes and infects the way that the legal system works and the religious system works, but that it infects all kinds of ways in which people look at Indigenous people, and it continues to animate what's going on. Now, you may or may not be aware that many religious organizations, the World Council of Churches, the Episcopal Church, the Friends, the Quaker Church in the United States, and the Anglican Church of Canada, a number of others have adopted resolutions repudiating the Doctrine of Discovery. And although this is a welcome, and in fact I wrote some of the resolutions, my feeling is that it's only the beginning. In part because I think many people who are a part of the larger society do not understand that we're talking about something that is living and real today. And when they repudiate the Doctrine of Discovery, it is my experience that they think that they're repudiating something that happened long ago and that is not alive today. So it is like the church saying, well, we're sorry that we used the language of discovery at one time, and now we'll try to speak about it more carefully. It fails to recognize that the disposition from the land, which is the result of the Doctrine of Discovery, is not only ongoing, in many ways it's accelerating. And precisely because these ideas are still animating so much of the way that people think and look at life. So the church has a long way to go in order to truly repudiate the Doctrine of Discovery. And there are too many ways in this short span of time to discuss all of those aspects. But for those of us who remain a part of the church and struggle to maintain an Indigenous identity within the life of the church, this is our ongoing struggle and battle. The way that we experience it from our fellow church members is that they simply do not understand our reality. They can't seem to wrap their minds around it. So that when we talk about Indigenous forms of accountability, they say, well, can we help you with that? And the whole point is you can't. You just absolutely can't. And so for us, anything that treats Western ideas, practices, values, and ideals as being normative is a part of the Doctrine of Discovery. So that any norm placed upon us that does not allow our elders, for instance, to make the decisions about who we are, what we are, how we do it, and that sort of thing, is a part of the Doctrine of Discovery. I would point out one other aspect of it. The Doctrine of Discovery is, I think, a part of the general attitude that this globalizing Western society has towards, not only towards the people of the land, but toward the land itself. This idea has been globalized and exported all over the world, and is now hurting Indigenous people all over the world in many, many different ways. And so this idea is not only affecting the people of the land, it's destroying human civilization. It is so critical at this point for humankind to wake up from this hypnotism and to begin to look at life and all that is in it in a very, very different way. So I would just like to say very simply, especially to the church people who might be present, that we have just begun in the repudiation, in articulating that repudiation, to begin the actual repudiation, which really requires a much larger conversion of mind and morals than anybody has anticipated. So this whole discussion is a part of what I think the remedy is, but I think it's very critical, and I used the term yesterday, that people of goodwill understand that the doctrine of discovery describes a moral wound in the way in which societies in general, especially globalizing society, views people, and the people of the land and the land. It is, I think, it is very urgent, especially for the people who animated this thought and this process, to begin to redo it.
Hi, Bishop. What a wonderful presentation, and I think providing some great sort of points of discussion, perhaps for our Q&A session, but also sort of reminding us of some of the critical aspects of the Doctrine of Discovery, stated in such simple terms. I really appreciated that. And I thought of our Cree word for wake up, which is once gut. How many times I've heard that, not just in the context of wake up, it's the morning, but also wake up and be alive to whatever the discussion is or the situation might be. And for us as Cree people, one of the things that we're taught as children is when we are alive to the world around us and listening, we don't just listen with our ears, we listen with our entire being, which also means our heart, our eyes, everything we can feel with our bodies, and the kinds of connections, the kinds of important connections to land and to others around us. So thank you for that presentation. We'll now move to Mr. Wetke from the Assembly of First Nations, who's going to provide us with a bit more of the legal context for the Doctrine of Discovery.
Good morning, everyone. My name is Stuart Wetke. I'm General Counsel with the Assembly of First Nations. My colleague Will Dave was supposed to be here. Unfortunately, he had to go to Bonn to engage in some of the climate change discussions. So he asked me to fill in for him, which I gladly did. It's always nice to be among good people and a good panel. The Doctrine of Discovery itself does have, as mentioned earlier, a lot of legal implications in how it deals with Indigenous peoples around the world. Really, the Doctrine of Discovery is an international norm-setting discourse with respect to asserting European sovereignty or European ideas over the global population. For Indigenous peoples, the Doctrine of Discovery essentially minimized Indigenous nations, stripped us of our self-determination, our rights as nations under international law, and really put us as a subset of different nation states or different groupings. Really, when you look at the doctrine in its early stages, it was about civilizing people. Europeans came over, much of the world was uncivilized. The Americas, they talk about as being uncivilized. Even the first Prime Minister of Canada, John D. MacDonald, described the Indigenous peoples as savages. Residential schools were needed to de-Indianize a population, basically to take the Indian out of the child. Really, they were seen as, Indigenous peoples were seen as something that was less than human in many respects. And the doctrine of discovery supported and reinforced that type of thinking and that paradigm that was applied to Indigenous peoples around the world. It's really about European superiority compared to Indigenous peoples' inferiority. What is the Doctrine of Discovery? Grand Chief Ed John talked about the papal bulls, and that is partially where it originated, but really it originated in some of the old international law with respect to conquest. Now, when Chief Justice Marshall of the United States talked about, Chief Justice talked about the Marshall cases in the United States, the American experience is somewhat different from the Canadian experience. Under the old international law regime back in the before democracies, all the rest of that stuff, really international law operated as whoever had the might was right. So various nations could be conquered by other nations, and once you were conquered, you lost your right to self-determination, to be a sovereign or independent. And so when you look at the Marshall cases and the American, the U.S. Indian wars that happened in the 1800s, a lot of that did result in wars, conquest, that type of thing. So when Marshall was speaking about the Doctrine of Discovery, he was looking at it possibly through that paradigm. That reality does not exist in Canada. There were no wars between the Indigenous populations and the Crown. We entered into treaties, we entered into agreements where we agreed to share the resources of the land. We agreed to coexist side by side, not interfering with each other. Those types of discussions took place. There was not conquest. Therefore, it could be argued, and it is being argued by many Indigenous people today, that we never lost the right to self-determination, that our sovereignty still exists. So the Doctrine of Discovery, when it's applied between the United States and Canada, is somewhat a bit different when you look at the history. But really, the subset, the ideas behind the Doctrine of Discovery is still present, as mentioned today, with respect to the case law. And that there are a number of judgments that have been rendered by courts throughout Canada that sort of reinforce the Doctrine of Discovery. And there are other legal fictions that are being reinforced by the courts. I mean, Australia for the longest time was looking at terra nullius as basically that nobody existed in that land prior to the Europeans discovering it. That legal fiction underpinned a lot of the discussions that happened in Australia with respect to the rights of Indigenous people. We see some of that here in Canada, not the same words that are being used, but still legal fictions are being applied by Canada, basically reinforcing the Doctrine of Discovery. And in international law, there is some movements with respect to changing some of those doctrines. There was one case in eastern Greenland where the Permanent Court of International Justice stated the following. The word conquest is not an appropriate phrase, even if it is assumed it was fighting between the Eskimos which led to their downfall of settlements. Conquest only operates as a cause of loss of sovereignty when there is a war between two states. By reason of the defeat, one of them loses sovereignty over territory that passes from the loser to the victorious state. The principle does not apply in a case where settlement has been established in a distinct country and its inhabitants are massacred by the Aboriginal population. So you see that when it comes to Indigenous peoples asserting the land through conquest and defeating some Europeans, the same rules don't necessarily apply, but when the Europeans come to discover other continents, other places, the Doctrine of Discovery does apply. In the Cayuga Nation case in the U.S., another quote from the U.S. court, it basically states that from the time of discovery of America, Indian tribes have been treated under the exclusive protection and power which, by discovery of conquest or secession, held the land which they occupied. That was done in that was quoted in one of the cases there. The court also made the following statement, basically comparing an American Indian tribe to a corporation. It says the situation of the Cayuga Nation is different from that of the ordinary corporation, in which it has no small margin of self-determination. Such a legal unit cannot change its national character by its own act. See North and South American Construction Company case. Moore International Arbitrations, they're quoting from there. Even less than such thing is possible in case of an Indian tribe whose dependent condition is well settled as its legal position is anomalous. Such tribes are a state of pupillage. Again, U.S. courts are looking at indigenous peoples and indigenous nations, for instance, as something being less. It's not a nation, they're not peoples. They're really something lower than that. And even corporations have potentially more rights than some tribes, and that's what they're getting at. In the Canadian context, Doctrine of Discovery really deals with the courts talk about the Crown having exclusive jurisdiction in North America. And the courts have made a number of statements in its judgments over the past with respect to the Crown having certain rights, and that since the assertion of sovereignty, since the Crown asserted sovereignty over Canada, that lands and minerals, jurisdiction over a number of things, all vested in Canada or in the Crown. But the courts have also stated that Indigenous peoples' laws, the laws that existed here prior to the European, really ceased at some point. And to the extent possible, some of the laws did survive, but they were absorbed in Canadian common law. For instance, with respect to adoptions, custom adoptions that First Nations have. First Nation people can still adopt children through the customary means, but that's done through common law by Crown, by Canada recognizing that jurisdiction of Indigenous peoples. When it comes to other jurisdictions that Indigenous peoples do have, such as control of the lands, the resources, licensing for fishing, or that type of thing, Crown basically states, well, that jurisdiction really doesn't exist. Our jurisdiction, our statutes override those jurisdictions. Therefore, our laws will apply to that. So that's how it's really playing out in Canada with respect to Indigenous peoples. And you always hear the same thing. Canada is founded on two founding nations, the English and the French. Nowhere in that mix is the Indigenous peoples. What's also of interest with respect to Indigenous peoples here in Canada at this point, the Crown still recognizes that, I should say the courts still recognize that First Nations have limited jurisdiction or limited personality. They talk about various organizations, people having powers of a natural person, power to enter into contracts, make arrangements, that type of thing. People have that, individuals have that, corporations have that, governments have it, municipalities have it. When it comes to First Nations, the court said really First Nations don't have it. They have it to the extent they can enter into financial or transactional arrangements, but really they're not natural persons under law. By being organized under the Indian Act, really that gives them the status as somewhat of a natural person to enter into, have powers to do certain things. But really they're not like any other organization or government in Canada. The only way that that's is basically overridden is through a self-government agreement where First Nations enter into self-government arrangements with Canada and the provinces. And even in those cases, it's really a municipal type of powers that the federal government is looking at providing First Nations people. So really, coming from an Indigenous perspective, you're once nations. All of a sudden, you become less than that. Now you're really becoming municipalities. And that's really not what our forefathers entering into the treaties and agreeing to sign lands, and share lands with the newcomers had envisioned. And even some of the language the court uses today describing Indigenous people sort of empowers or follows the Doctrine of Discovery. For instance, in the Keewatin case, the Supreme Court of Canada described the Grassy Narrows people as the Grassy Narrows First Nations descendants of the Ojibwe signatories of Treaty 3. In the Manitoba Métis case, over a century later, the descendants of the Métis people seek a declaration to the courts. We were once peoples, now of course we're defining us as being descendants of the original peoples. In the Kiwi case, they're not the descendants of the Ojibwe. They are the Ojibwe for all intents and purposes. The Métis are the Métis. We're not descendants of some group that once had sovereign powers and all of a sudden you're something less than that. So even today, the courts are reinforcing some of these legal fictions to really undermine Indigenous peoples. Because what would Indigenous peoples be under international law, when you really look at it? Under international law, people is someone that has a distinct culture, distinct language, common history, a certain land base or a territory. All First Nation groups, Indigenous nations in Canada, whether they're the Cree, the Ojibwe, the Iroquois, the Huron, the Mi'kmaq, the Mi'kmaq, the Blood tribes, they all have those characteristics. They are nations in international law. But a number of people or governments are trying to downgrade that through other instruments and say, no, you're really minorities with certain rights, but you're not peoples, which is completely wrong. They fit the category of peoples and they're entitled to self-determination. And the Doctrine of Discovery and some of these other legal fictions sort of reinforce that. And as I mentioned, residential schools sort of looked at de-Indianizing the Canadian First Nation population. Just a few more comments on the way people today look at the same issues. Because the younger generations really don't talk about discovery, Doctrine of Discovery in those traditional senses. But they still look at the same issue through a different lens. For instance, when they talk about we're all Canadians. Are we really all Canadians? A number of Indigenous peoples would say, oh, no, we're Ojibwe, or we're Ojibwe, or we're Iroquois, Mohawk. We're not Canadians. So people say, well, you're all Canadians, you should follow into our system and be like us. Younger people will talk about why should First Nations be treated differently? Why should they get special rights that we don't have? Why should they get their education paid for? Well, this is all pursuant to treaties and agreements that we have. So when you look at different generations and how we look at the same issues, it really looks at how do we keep undermining the Indigenous population to ensure that Canada we know today will apply to certain broadly political, but still looking at how can we fit First Nations into that mold? How can we fit First Nations in a square box into a round peg? And that's what they're really looking at, trying to find ways of doing that. But really, when you go back to the underlying basis between the relationship between First Nations peoples and the newcomers, it's really based in treaties, whether it's the historical treaties, the minor treaties, or even today, the modern treaties. And I think that is what should be on the table as opposed to some of these legal fictions that are being reinforced. Thank you.
Hey, Stuart, thank you so much for your presentation, very thought-provoking, and actually reminded me of a quote from an author named Thomas King, who wrote a book called The Inconvenient Indian, which is how I feel most of the time. And the quote was about the word recognition, and what does it mean to be recognized, I suppose under Canadian law or elsewhere. And he said, the word recognition makes me feel almost real. That always really stuck with me. So now I'll ask Jennifer Preston to commence with her presentation.
Thank you, Danica. And in case I forget to say this at the end, I also wanted to thank Rachel and Kira from my office who did the majority of the logistical work to make this panel happen today. I want to start, I am speaking on this panel as a staff person. I work for the national justice body of Quakers in Canada, and I'm speaking from that role. And I'm going to speak specifically to the work that Quakers have done around discovery and repudiating discovery. But before I do that, I wanted to give you a few elements to create a context for that work. And one of them is I do want to quote to you from the UN Declaration on the Rights of Indigenous Peoples. And we actually have copies on the table here at the door. There's booklet copies if people don't already have one. And I should say that the coalition that produced those booklets has distributed about 150,000 copies of them to date. So we're very pleased about that as an educational tool. So in the UN Declaration, the fourth preambular paragraph reads, "All doctrines, policies, and practices based on advocating superiority of peoples or individuals on the basis of natural origin or racial, religious, ethnic, or cultural differences are racist, scientifically false, legally invalid, morally condemnable, and socially unjust." And I also wanted to say that under Canada's constitutional framework, it is important to remember that Crown sovereignty and legislative power is not absolute, and that's been affirmed by the Supreme Court of Canada. In the Haida Nation case in 2004, the Supreme Court stated there is a need to reconcile pre-existing Aboriginal sovereignty with assumed Crown sovereignty, and that's important, and I'm going to come back to that. This reconciliation, of course, has not taken place, and that's part of the work that we are all doing here this week. And I think that right now, at this critical time in our history, when people have come together for the final event of the TRC and to receive the report from the commissioners tomorrow, that all faith groups, and indeed all sectors of society, need to be asking themselves the question, how are we carrying forward the work of reconciliation? What are we doing next week about reconciliation? And for reconciliation to be real, Indigenous legal orders must be respected. This is something alluded to by the other panelists. And also in our Constitution, there is recognition that there's 3 orders of government. But in addition to the orders of government for federal and provincial, there's also Aboriginal order of government. This is also affirmed in RCAP. And those need to be recognized and respected as we're going forward in this work. There has to be a paradigm shift. And that paradigm shift, one of the tools to make that happen is the UN Declaration. And I think it's important for all faith groups to engage in the work, to learn about the UN Declaration, to learn about the Doctrine of Discovery, and to be engaging in national conversations and issuing national statements that both affirm the UN Declaration and work towards the implementation of that, and what does that mean, and to repudiate the Doctrine of Discovery, and what does that mean, and what does dismantling that look like. And for those that don't know, Quakers are one of the few faith communities that were involved for the entire history of the development of the UN Declaration in both Geneva and in New York. And when after the Declaration was adopted, had issued a national statement from the faith community on the Declaration and its implementation. And of course, our work on Doctrine of Discovery is part of our work in implementing the UN Declaration. So just briefly to tell you the journey of the work that we did around to repudiate discovery, one of my former board members who's actually here today, Monica, attended a side event at the UN Permanent Forum on Indigenous Issues probably about a decade ago. And the side event was on the papal bulls and the Doctrine of Discovery. And she came back from that and she said, have you heard about this? And she said, we have to do some work on this. And so that internal work started at that time. And over the period of the past decade, the UN has done a lot of work on the Doctrine of Discovery. And Grand Chief Ed John has authored a study, the second UN study on the Doctrine of Discovery. And we have copies of that here as well for people. And so internationally, this work was being done, and also domestically. And as Bishop Mark said, there's many faith bodies, particularly in the US, that have done a lot of work on this, and the World Council of Churches. And so the work that we did involved putting together an information package that we sent to all Quaker, what we call them meetings, but congregations, explaining what discovery was, explaining how it still exists in a contemporary context, and asking those bodies, the communities, to do like a study session or a workshop to discuss this, because we wanted to come forward and create a national statement repudiating it. And we went through a period of several months where people were sending in questions and clarifications, and some of it was hard work for people. People were saying, well, but then what does that mean? Does this mean that I have to give up my house? People were having to have those conversations, which was really important for people to be doing that work and to be having to think through these challenges about what does restitution mean? What does respecting land rights mean? And that needed to happen at the local level. And out of that was produced a national statement, which the Quakers affirmed at their national annual gathering in 2013. And I'm not going to read you the minute in the interest of time, but part of that minute was it included affirming our repudiation of discovery, and it also had action items for the Government of Canada for engagement, which included looking at land that was taken illegally and providing mechanisms for effective redress. And it also ended with that the support for a process of building right relationships among people in Canada and asking ourselves, what is the process of bringing reconciliation and healing, and how do we proceed with that? Because this work is really only just beginning, and saying, as Bishop Mark said, it's one thing to say that you repudiate it, but what actions are you taking to make that real? And one of the actions that we have taken that overlapped with this process of us producing a national statement was that we were interveners in the Chilcotin Nation case before the Supreme Court of Canada. The Chilcotin Nation case is a landmark case before the Supreme Court. Judgment came down not quite a year ago. And this was the first time the Supreme Court of Canada affirmed Aboriginal title. And when we became an intervener in that case, we did it jointly with Amnesty International, and we did it. We asked permission and received the blessing of the leadership in British Columbia to be an intervener in that case. And our role in our intervention was to draw the court's attention to international human rights law and the UN Declaration, and how that has to be used when courts are looking at land rights cases. But also, in our intervention, and one of the reasons that we engaged with this was because in 2012, the BC Court of Appeal had invoked the Doctrine of Discovery when they made their ruling in Chilcotin Nation. And so as the appeal went forward to the Supreme Court of Canada, we argued in our intervention that the Supreme Court must firmly reject that, and that the principle of discovery is a continuation of colonization, and that it amounts to a violation of the Charter of the United Nations. Now, interestingly enough, and I have my own theories on why, in the judgment, the court doesn't refer to discovery, but what it did do was it rejected terra nullius. Terra nullius is often viewed hand in hand with discovery or considered an element of discovery. And what the court said was the doctrine of terra nullius, that no one owned the land prior to European assertion of sovereignty, never applied in Canada, as confirmed by the Royal Proclamation of 1763. This is a very important statement for a lot of reasons. One of them is the court is affirming that the Royal Proclamation applies to all of Canada, and the other is that it places the Royal Proclamation firmly in the constitutional framework, and in the constitutional framework and the equitable principles of the Constitution applying with the Royal Proclamation. So now you have those equitable principles are precluding the doctrine of terra nullius from applying in Canada. So these same principles must also prevent the application of the doctrine of discovery as applying in Canada. And in fact, at the anniversary of the Royal Proclamation, Aboriginal Affairs Minister Valcourt said the doctrine of discovery never applied in Canada. So then a question I think we have to be analyzing is, so if the doctrine of discovery is not what Canada used to assert sovereignty, then what is Crown sovereignty based on in Canada? And that is a question that needs much more work done and much more analysis done. And this, of course, was part of the Chilcotin Nation case, and it is also obviously part of the Haida Nation case when the court said it's assumed Crown sovereignty, and it has to be reconciled with pre-existing Aboriginal sovereignty. So really the task before us is to move past the denial and understand that Canada, as a modern-day nation-state, is founded on theft and fraud, and that reconciliation includes restitution. It is about land rights, and we have to be respecting those rights, and we have to be working in solidarity with Indigenous peoples in that respect. So it's really important, and I know that this is something that Commissioner Marie Wilson has said a lot about the work of the TRC. This is not an Indigenous rights issue, this is a rights issue for all of us. And we have to be engaged in that. And it is our role to engage with solidarity with Indigenous partners in looking at these things. And how do you do that? I mean, in faith communities, you can be having conversations about the Doctrine of Discovery, about the UN Declaration, and working around implementation. As individuals, you can contact lawmakers. I mean, you have representatives at the provincial and the federal level who are lawmakers. Lawmakers have to hear from their constituents. When we first started doing the UN work on the UN Declaration, as Quakers, we had a Canadian government bureaucrat say to us, well, if you have a constituency, where are they? I mean, what mattered to him was, who cares about this issue? Lawmakers need to know that Canadians care about this issue. So you can contact your representatives and raise that with them. And the other piece that's so critically important and is so much a big part of the work of the TRC is the education system. Kids have to learn this in school. If you have children or grandchildren in the school system, what part of the curriculum are they teaching you? Yesterday, Premier Wynne spoke about the changes in the Ontario curriculum. So is that being channeled down? Is that actually being done in teacher training? Is it actually translating into active work in the classroom? Are kids learning about the real history of Canada? When I went through the Ontario school system, the history of Canada started when the British and the French arrived here. And so how much has that changed? And how much is it going to continue to change? And that's really important. As individuals, you can press for those types of changes. It needs to be that all Canadians are playing a role, an active role, in changing that paradigm. And we're not going to arrive at any kind of reconciliation until that paradigm has been changed.
What a wonderful presentation and a great segue into our Q&A discussion.